5, 4, 3, 2, 1, start.
The question raised in this appeal is as to whether profit on sale of share was capital gain or business income of the SSC full stop. The SSC had shown the same as long-term capital gain which was not accepted by the assessing officer who treated it as business income full stop. The CIT as well as the ITAT has held it otherwise full stop. The main reason because of which the assessing officer treated the income from sale of shares as business income was that the SSC was in the business of sales/purchase of shares full stop. Certain other income from the sale of shares was shown as business income full stop. The CIT, while reversing this order of the assessing officer and treating the profits on sale of shares as capital gain, found that the shares in question were of Sri Ram Private Limited. 900 shares of this company were purchased by the SSC in the year 2000-2001 and were shown under investment portfolio full stop stanza. The SSC received additional 356 shares on merger of Ranganathan India Limited with the SSC in that year full stop. These shares were also shown under investment portfolio full stop. Subsequently, in the financial year 2002-03 and 2003-04, SSC received 4 lakh shares of SRPL as split/gift/bonus full stop. In this manner, SSC was holding 5 lakh shares of SRPL on 21st April 2003 full stop. These shares were never treated as stock in trade, but from very beginning they were shown under investment portfolio full stop. After detailed analysis of the fact, the CIT relied upon the findings of the fact that the SSC was maintaining 2 separate portfolio accounts, one for the purpose of investment and other for business purposes full stop. Insofar as shares in question are concerned, they were purchased with predominantly intention of investment full stop stanza. The objective was to clear these shares securities as investment and enjoy the income therefrom, and not to hold these shares as stock in trade with the intention to trade in them full stop. In the process, the CIT perused the balance sheet as well as accounts showing 2 portfolios, that is, as investment and as stock in trade full stop. It was also found that the explanation of the shares held by the SSC into 2 portfolio had only been disputed by the revenue full stop. The SSC, even otherwise entitled to have these 2 portfolios as per given accounting standard 13 issued by the Institute of Chartered Accountants of India on accounting for investments, which provides that the company is required to value its short-term investments, that is, investment which have been made with a view to resell at a profit in a short period of time at cost or fair market value, which is lower, whereas long-term investments are required to be valued at cost unless there is a permanent diminution in their values full stop stanza. Such a practice was even in consonance with the judgments of the apex court and the high courts full stop. After a detailed analysis of the facts and having regard to the legal principles in mind while holding that profit on sale of shares of SRPL was assumable as capital gain full stop. The promoters of the appellant were also co-promoters of the SRPL full stop. The appellant has been a substantial shareholder in SRPL since 2000-2001 full stop. The shares in SRPL were acquired as part of promoter holding, which is evident from page 22 of the paper book full stop. Substantial part of shareholding of the appellant in SRPL has resulted from shares received on account of bonus/gift/merger and not on account of purchase made by the appellant full stop stanza. The shares of SRPL have been valued at cost by the appellant in the profit and loss account, which has not been objected to by the statutory auditors. Full stop. The sale of shares of SRPL in the captioned assessment year was made out of investment portfolio and not out of stock in trade. Full stop. Sale proceeds of the shares have not been reflected as turnover and profit derived being shown as profit on sale of investment. Full stop. The appellant has held all his investment for long period with an objective of earning dividend income therefrom. Full stop. Stanza. The appellant had even converted the shares of SRPL held as stock in trade into investment in the immediately succeeding assessment year, that is 2006-7, which further fortifies the conduct of the appellant to hold the shares as investments. Full stop. Further, in my considered view, nothing prohibits the appellant from simultaneously holding some shares of on investment account and some others as stock in trade. Full stop. The Madras High Court, while dismissing appeal question referred by revenue that whether the tribunal was right in holding that the profit on sale of shares was to be treated as capital gains. Full stop. A company can hold some shares as stock in trade for the purpose of doing business of buying and sale of such shares, while at the same time it can also hold some other shares as its capital for the purpose of earning dividend income. Full stop. Here, the shares in question were held as the SSC's capital and not as in trade. Full stop. Hence, there would be capital gain and not business income. Full stop. Stanza. Hence, we answer the question referred in the affirmation, that is, in favor of the SSC and against the department. Full stop. The CBTD has Wide Circular number 10/2006 dated 14/6/2006 clarified that an SSC can hold shares on both portfolios as an investment or stock on trade on the following words, that CBDT also wishes to emphasize that it is impossible for a taxpayer to have two portfolios, that is, an investment portfolio comprising of securities which are to be treated as capital assets and a trading portfolio comprising of stock in trade which are to be treated as trading assets. Full stop. Where an SSC has two portfolios, the SSC may have income under both, that is, capital gains as well as business income. Full stop. The ITAT went into the entire gamut with the dispute all over again and accepted the aforesaid findings of the CIT. Full stop. It took note of the judgment of Gujarat High Court in CIT versus Raman Dangi, wherein the High Court has given a few broader tests for determining the nature of transaction. Full stop. Stanza. The first test is whether the initial acquisition of the subject matter of transaction was with the intentions of dealing in fifth term or with a views to finding an investment. Full stop. If the transaction since the inception appears to be impressed with the character of a commercial transaction entered into with a view to earn profit, it would furnish a valuable guidance. Full stop. The second test, why and who for what purpose of the sale was effected subsequently. Full stop. The third test is as to how the SSC dealt with the subject matter of transaction during the time and assets was with the SSC, whether it has been treated a stock in trade or been shown in the book of accounts and balance sheet as an investment. Full stop. Stanza. This inquiry through relevant is not conclusive. Full stop. The fourth test is how the SSC himself has returned the income from such activities and how the department has dealt with the same in the course of preceding and succeeding assessments. Full stop. The factor, though not conclusive, can afford goods and cogent evidence in judge the nature of transactions and would be a relevant circumstances to be considered in the absence of any satisfactory explanation. Full stop.